Welcome everyone to today's webinar, Auto Renewals, Tariffs, FTC's Negative Option Rule, New State Laws, and More. A webinar that's brought to you by Venable's Auto Renewal Solutions team, or VAST. I'm Shahin Rothermel. I'm a partner in our advertising group. I'm joined today by my partners Ellen Berge and Ari Rothman. We'll be talking about quite a lot today, and we're going to ask you as the audience to stay on your toes a little bit because there will be some polls that we want to make this a little bit more interactive than normal. We also welcome any questions, but we have a ton of content today. So please use a Q&A chat section, and if we cannot get to it immediately on the today during the webinar, we'll talk to you afterwards. What are the latest developments now in automatic renewal programs? FTC's click to cancel rule, or the updated negative option rule, primary requirements are going to take effect in May 14th. I guess today is May. I already forgot that. So the rules regarding disclosure, consent, and cancellation that we'll talk about. We anticipate significant enforcement by the Federal Trade Commission. Why? Because this is one of the only rules that the FTC is currently defending the legal challenge to in court, and because we're seeing quite a few complaints, challenges, and settlements coming out even under the new administration. So if you thought that all things FTC would die, but you're not right. We're also going to see the amendments to California's Autorenewal Law take effect in July, and there are a lot of new gnarly requirements there. With the tariffs coming up, we're going to see some potential impacts on automatic renewal programs that we'd like to talk about. We've got a lot of state law enforcement by New York and California's Auto Renewal Task Force. The class action plaintiffs bar is as active as it's ever been in the past. We are seeing a ton of cases both filed and that our clients are getting behind the scenes as confidential demand letters. New state auto renewal laws are coming out. We're also seeing new challenges under states' honest pricing, junk fee, drip pricing rules, coupled with automatic renewal challenges. And even if you are selling to business, we've gotten a lot of questions. Do these laws apply if I'm selling to small businesses? Those transactions are going to be included in a lot of new state laws and proposed laws, as well as the FTC saying that they're going to use that click to cancel rule in business to business transactions. So with that, why don't we roll into some of the requirements? Ellen, would you like to talk about those?
Sure. So the first one that we'll start with is actually a part of the new FTC click to cancel rule. And we like to start here because it's something that we're going to get to usual requirements of disclosures and consent and those types of things in a minute. But click to cancel has a general prohibition that that you cannot misrepresent any material fact of the underlying good or service or anything about the automatic renewal offer. And that broadens this law considerably. So now we're talking about claims that could be made about the product or service that you're selling. So how well it works, a health or safety claim, the purpose for what it's could be used for, and how effective it is, possibly, certainly things like cost, but other things, if it's a service contract and you want to charge folks an early termination fee, or even if you think annual subscriptions, and somebody cancels halfway through the year and they lose their benefits and don't get a refund, is that now material information that is important to their decision about whether or not they would sign up for this automatic renewal program in the first place? So that's, it's something really to keep in mind. And again, that has been effective actually since January 14th. Moving on to where we'll spend where we and you will spend a lot more time sort of thinking about how you present your automatic renewal offers. Laws have always had disclosure requirements, and this is what we boiled it down to here. We've put on the left side the click to cancel, the FTC requirements, and there's a lot of overlap between those and the state law requirements, but you'll see the state law requirements. We use California and New York. So we sort of mush them together for listing out the primary disclosures because they are very similar and they track a lot of what states are generally requiring. But it is stuff that you would expect. How much something is going to cost, the deadline by which somebody has to take action to cancel, or else they're going to continue to get charged and receive products and services. Information about canceling and the fact that, it is on the consumer to cancel. They've got to take some affirmative act to cancel to get out of it. All of these things go into it. And I believe that these slides will be available so you can take a look at these a little bit more clearly.
All right, everyone wake up. We've got a poll for you. The poll is, which of the following are prohibited misrepresentations? The existence of an early termination fee or ETF, a no refund policy, a shipping protection fee that's disclosed on the checkout page only, A and B, or all of the above. And I think we've got Ashton controlling the poll, so that should pop up here. Give everybody a couple seconds here to answer. All right, let's take a look at the results.
Well done.
Well, Ari, can you see the results?
Well, there must be some technical issues. So three out of 91. I don't know who can see what, but the existence of an early termination fee, a no refund policy, 2% responded with that. A benefit that only applies to debit cards but not credit cards, 9%. A and B, 7%. A and C, 5%. And all of the above, 67 out of 91 who took the poll, 74% said that was the right, or that was correct, all the above. And I believe all the above is the right answer. Shahin, do you want to go through that?
That is the right answer. That is the right answer. And when in doubt, you should assume that a regulator or plaintiff is going to challenge it as a prohibited misrepresentation, even if a reasonable consumer might have expected it. And the FTC made clear in its negative option rule in the preamble there that it declined to adopt this idea that it's only going to prohibit misrepresentation specifically related to the auto renewal element, but also to any other aspect of the transaction or of the underlying product, as Alan just said. Let's talk about the requirement for the disclosures to be clear and conspicuous. Ari, could you talk about those a little bit?
Clear and conspicuous, what does it mean? The first bullet pretty much says 80% of what you need to know. Unavoidably noticeable, easily read and understood. If we are defending a demand letter or an enforcement action by the government or a threat and enforcement action by the government, class action, whatever it is, I want to be able, and we as lawyers want to be able to tell the judge, tell the opponent, tell the government that here's where the disclosure is, and you can't miss it. You can't misunderstand it. It just glows in the dark. And so that complying with that one bullet will reduce risk significantly. There are, as you can imagine, in the California law in particular, tons of nuances around it. So, for example, the disclosure needs to be made in the same means through which the communication is presented. That's most apt for like TV ads. It has to be visual and audible because a TV ad is both visual and audible. Visual disclosures have to stand out by size, contrast, location, length of time appearing on screen. Audio disclosures must be at a volume where people can hear it the right speed. You can't go like it has to be the right cadence. And the internet, mobile, and other disclosures must be unavoidable, obviously, on the internet. The visual proximity needs to you need to have it close to the offer, and the terms, the disclosure cannot contradict inconsistent information elsewhere. So it has to be consistent throughout. You can't have a door opener that says one thing and then in the actual terms a few screens later say something different. And obviously the disclaimer must appear in each language in which the representation that requires a disclosure is made or appears. Here's an interesting point, moving on to the next one, that we think is worthy of clarification. The FTC's final click to cancel rule deleted the sentence that's on the top here. A disclosure is not clear and conspicuous if a consumer must take any action, such as clicking on a hyperlink or hovering over an icon to see it. And so reading that in isolation, someone might think, oh, well, we can just have the terms in a place where they can only be seen by hovering or clicking. That's not exactly the rule, and that's not the rule. It's certainly in state courts like California. A clear and conspicuous disclosure still must be unavoidable. So I would almost ignore this.
Recording in progress.
I got some feedback there. I'm not sure what that was for. But really focus, keep it on unavoidable. So we're flagging this just so there isn't sort of this undue reliance on that deletion. I think now we can talk about what express informed consent is, and I'll kick it over to Shane.
Sure. This is a question everybody asks. How do you get consent? To get express informed consent, the FTC says that you have to get that consent separately from any other portion of the transaction. And that really raises the question of what is separate from any other portion of the transaction. Does that mean from the actual purchase button? Does that mean from even the terms and conditions and privacy policy? So we anticipate this is going to be something that we'll see a lot of action around. It also has to exclude any information that interferes with, detracts from, or otherwise undermines the ability to provide their express consent. What I interpret this to mean is no marketing speak in that. And you have to keep or maintain verification of the consumer's consent for at least 3 years. And one of the questions we have here is, can you require people to click a hyperlink to see the disclosures if you also require them to accept them? And the FTC, although it removed that language, would say that it needs to be unavoidable. So the reason it removed the language regarding hyperlinks is because it has that requirement that those be unavoidable. Under California's amended law, companies have to obtain the consumer's express affirmative consent. They added the word express because the task force and the people who were making the law wanted to have a better argument that this requires an empty checkbox. The previous version of law only said affirmative consent. And a lot of courts interpreted that language under similar state laws to mean that there was no checkbox required. And we anticipate we're going to see some litigation surrounding this.
Okay.
Let's go to the poll. Ari, do you want to handle this one?
You're on mute, Aria, maybe.
Yeah, sorry. So, is a checkbox required to obtain consent along the lines that Shahin just laid out? Is an unchecked checkbox, it's really how we should ask the question, required to obtain consent? We'll give you all a few minutes to answer that. Is it required? And I don't know if we
Probably
enough
done.
time
That's,
Yeah, let's
expired.
go
that's
ahead.
an easy
Let's go
yes
ahead
or
and
no.
see the results.
Okay. That's actually a pretty good split. I don't know who can see what. 65 out of 114, 57% said yes. 43%, 49 out of 114 said no. The answer is no from the perspective of there's no statute that expressly requires an unchecked checkbox next to disclosures. The answer is yes if you are dealing with CART, the California Automatic Renewal Task Force, some class action plaintiffs. Not sure where the FTC stands on it in the year 2025. So it is yes and no. If we're forced to litigate this, we say no, it's not required. It's plain statutory language. It's not there. If we are dealing with CART will tell us in all of its settlements, you have to have an unchecked checkbox next to it. So is it a best practice? Absolutely. I mean, it's very hard. I mean, it's very, very hard to come up with a consent mechanism online that is more provable than that, assuming the language next to the unchecked checkbox complies with all the other requirements, all the content requirements. So that's that poll question. Next, we can talk order confirmation, another step in the flow. It's over to Ellen.
Okay, so we've had people now seen the disclosures, they agree to the program. Now they really should get an order confirmation. It's required under many state laws, including our larger states. It's required if somebody's using a debit card under federal law, and those are out there, so don't forget about those. And it's otherwise a best practice and put in by the FTC in settlement orders with its defendants under the ROSCA law and other things. So it really is best practice. It's a good idea to do it. It's required in some places. So you're essentially going to restate the offer terms, remind people what they agreed to, remind them that they gave you an authorization to charge their payment method on a recurring basis and the amount and the frequency. And most importantly, perhaps, is telling them how to cancel and when they have to cancel by, because this is the email or whatever that people are going to go back to whenever they're trying to figure out what did I agree to and how do I cancel. And it's really important to have a good, clear order confirmation. It can help you a lot when you're trying to defend your practices and show that you've done right by the consumer. Actually, we see a lot of sort of weird confirmations where people sort of put terms. They try to comply by burying the offer terms like way at the bottom and fine grayed out print or something, but you really ought to make it clear and conspicuous like everything else. So anyway, so that's that. And then let's move on. So let's say now you're in the autumn, you're in the program. So, things are running smoothly. You've got people maybe going month to month, or sometimes longer terms where there's a lot of sort of annual programs out there. So the question here is, are notices of renewal or reminder notices required? And the FTC doesn't have a reminder or renewal notice requirement. There are some state laws that do, and these can vary a little bit. A lot of times in the states, if you have started something with a free trial offer that turns into a paid program, and these are fraught with all sorts of other issues too, by the way, if you're doing them. But there are some states that will require that you tell people before their free trial period ends that it's ending and that they're going to be charged, and make sure they understand like that they can cancel. There are some states that will require renewal reminders be sent whenever they're on a longer subscription, like an annual subscription, and they're hitting the year marker. A lot of times people forget that they signed up and it's a year or two later and it's pricier. So all of a sudden you're just going to hit them with like a $200 or $300 charge. That's surprising for a lot. That can result in chargebacks and complaints and things like that. So, not only is it required in some places, but another good practice, especially on those longer ones. And there are some sort of other state nuances in this that I think we'll touch on. But California was one area here where I'm not sure if it was clear.
Yeah, California, when they amended the statute, they have two different provisions related to renewal reminders for annual programs. And it's really unclear right now is, do you have to only provide an annual renewal reminder if somebody's term is 12 months or more, they're charged every 12 months? Or do you need to provide a renewal reminder regardless of the term once somebody hits that 12-month mark, just as a reminder, even though they're getting that physical product every month, or even though they're being charged every month for the digital product? It's really unclear right now under California law, and we anticipate we're going to start seeing challenges to those. We've seen some challenges already on renewal reminders under other state laws. So Ellen, do you want to talk about what happens if somebody changes the subscription terms?
Yeah, so there are state law again here, California, New York, others will require that you send notice of any material changes to the consumer. You want to give them plenty of advance notice and clear notice that it's changing. Include in that notice information about how they can cancel if they disagree with the change. Clearly, like a pricing change is going to be material, but there could be other things that you're changing. You're moving them from month to month to every 3 months or so, a billing frequency change. Or if it's like a bundle of services they're getting, maybe you're adding or subtracting what they're getting in their program. So these would all be viewed as material. There is new California law here too, and I'm not even sure I understand. This is another one.
This is a weird one. This is a very weird one. They said that you still have to get that. They said that you have to get additional consent if somebody agreed to a price change. And previously it was if you had a free trial 31 days or more, you had to get that additional consent. But now what the California law says is that if the fee charged under existing contract changes, you have to provide notice between 7 and 30 days before that fee change takes effect, with both a notice of the fee change and information regarding how to cancel. But what it says now is that including changes that somebody affirmatively agreed to in the existing plan or arrangement. In other words, if you disclose, hey, you're going to pay $5 today, and in a month you're going to pay $15, even if you disclose and get their agreement to that on the front end, it's not really clear, but I imagine we're going to start seeing challenges saying, hey, you have to send another notice. Now you got the acknowledgement, you got another notice, you got the annual notice. So the name of the game on a lot of these is be really up in people's faces about what's going on with the subscription. The more it's hidden, the higher the risk, the more transparent you are, the lower the risk. Ari, would you like to talk about the cancellation requirements?
So cancellation's a big deal. The first one, the two easy ways to get consumer complaints are not disclosing the terms. That's clear and conspicuous disclosures. The second is not letting them cancel easily. So the FTC has come up with some guidance on that, and as well as California. The first is you have to provide a simple cancellation mechanism through the same medium. So internet, telephone, mail, or in person. And the sellers must allow the consumers or provide that simple mechanism so that the consumers can immediately stop the charges that is cost effective, timely, and easy to use. It's fine to have them authenticate their identity or some sort of confirmation procedures so that way you don't have a bunch of random people canceling accounts and causing other problems. But you can't use those verification methods to thwart or delay the cancellation. And it's kind of like one of those know it when you see it situations. It needs to be quick, and the fewer steps that you have, the more likely it is to be found to be a valid authentication procedure as opposed to an invalid one. Now, in terms of where the mechanism needs to be, whether it's a button, a link, etc., it has to be easy to find and easy to use. So providing a clearly labeled cancellation button in a consumer's account or user settings is one example of a simple online cancellation mechanism. But what you can't do is have something like it may not be on a home page, but one of the web pages that says cancel here, manage your account here, and the user does that, and then when the user lands on that setting, on that page, it's difficult to find the cancellation mechanism. So the theme here is it needs to be as easy with as least friction as possible and immediate, or as close as you can get to immediate, with some authentication steps that, if that's necessary, can be implemented to prevent fraudulent cancellations. The cancellation must be through an interactive electronic medium. They can include text, chat, email within the scope of the online cancellation medium. Again, no barriers, and nothing should be implemented or introduced that would introduce unnecessary friction to do the cancellation. And there's no exclusion for those providing bundled services. So if you provide bundled services, you can't make it more difficult or ask a bunch of questions just because it's a bundle. You just need to be able to cancel. The consumer needs to be able to cancel the bundle easily and quickly. The same rules apply. There's no distinction. In terms of phone cancellation, that has to be at a phone number that is answered or records messages during normal business hours. Normal business hours are those hours in which the business would normally engage with its customers. Can't make telephone cancellation available only at inconvenient times to get around this rule. The seller doesn't have to physically answer the phone. You can ask the consumer to identify the subscription and leave identifying information, but you have to check those messages as quickly as possible. And really what should happen is if you're going to do that, that really should be a backup to live agents. Like if you don't have enough live agents, then it can roll to a pre-recorded message that allows a consumer to leave a message. But the live agent, make it quick. This is an easy, low-hanging fruit for consumers to start complaining if they get frustrated and can't figure out how to cancel. In-person cancellation, in-person sellers, you have to have alternatives to that, either online or by phone, but you can choose which one that is. But the phone call cannot impose a cost that creates an unreasonable barrier to cancellation. Same rules. The next slide is California law, and that's the mere cancellation rule. The ability to cancel or terminate needs to be in the same medium that the consumer used in the transaction. So if it's an online transaction, they need to be able to cancel online. If it's a telephone transaction, they need to be able to cancel by phone. You can't have an online purchase or cancel, online medium to enable the consumer to make the purchase, then have them phone in. You can provide it as an option, probably, but you can't make it the only means for cancellation. And it has to be prominent. Again, it has to be clear. It could be a link or a button, which can be located within either a customer account profile or within the device or user settings, and it has to be immediate. Cart wants it fast, not fast, as fast as it can be without any friction, unnecessary friction. What about mobile apps? There's less guidance on that, so the general rules would still apply. It still needs to be quick, and it has to be. It just has to be. It has to be fast. Um, so those are the rules on cancellation. I think I think Ellen,
Yeah.
maybe you have a poll
Let's-
question.
Let's go. So if you are trying to sort of facilitate quick cancellation, can you attempt to save the sale? So this is a poll question. I'll give you like 10 seconds.
We'll get the results here.
Okay. All right, counting down. All right.
I know what I voted.
Okay. What are we seeing? Okay, 73% of you said yes, you can attempt to save the sale. And that is true with a lot of caveats. So the FTC actually initially had a provision in click to cancel that said you can't. They didn't adopt that. They may revisit it. So right now you can, but you also want to pay attention to what else is going on with the state laws here and just practically what else we're seeing in the cases. So remember, you can't make it difficult to cancel. So if your save the sale attempt is too burdensome or lengthy or like, that could be viewed as an impediment, which is unlawful. And this is pretty much happened in the serious case, which we're actually going to talk about a little bit later. But here, customers were calling in to cancel in certain cases, and they were just subject to a lot of retention efforts and hard to sort of convey to the person on the phone that they really wanted to cancel and couldn't stop that. So we're seeing the law now, sort of California taking the lead in sort of addressing this more explicitly. So again, you can present an offer. Maybe you guys want to weigh in on how the California regulators are seeing this, but as we've been viewing is really just like a one attempt, and that attempt has to be sort of not obstruct somebody's ability to cancel it. So you really have to kind of do it simultaneously. And you can see if somebody's canceling over the phone, you've got to really kind of say like, no problem. You can cancel, but before you do, would you like to hear about, an offer to stay in the program and sort of kind of approach it that way? Or if somebody's online and they're canceling, you have to make it assure the person that they can cancel easily. Maybe they can click a button to cancel at the same time that you're sort of offering them a save offer or a, whatever it is. So be very careful here, because I think this is a place where we could see a lot of the lawsuits sort of say that you didn't follow this correctly.
That's right. And one of the questions we get is, can you do a survey? And is a survey considered a save, retention effort, or a demonstration of a benefit? And the California Autorenewal Task Force has said, yes, a survey is going to count as that one step. You basically get one step after somebody clicks cancel. What they're going to say is you get one step to either show a benefit, show the benefits they're losing, show a retention effort, or do a survey. They think that anything after that, somebody clicks cancel now, that means cancel now immediately. There's no further quote unquote hindrance, even if it's a one-click hindrance. That's what they'll say. Don't know that courts will agree. So stay tuned as we start to see more litigation under that. States, so much activity on the states in terms of new bills, new laws. really nitpicky requirements. So Colorado is going to say that a renewal term can't exceed 1 year unless somebody gives express written consent for a longer term. Vermont says that if you're going to do a year or more, that disclosure has to appear in bold type. I don't know how you prove bold on a when you're doing script in HTML, but I don't know. It also requires additional consent if you're doing 1 year or more. New Mexico's 10-point. North Carolina says it has to be at least 12-point bolded type if the terms change on auto renewal. And a court actually looked at that and said that the disclosure under general rules was clear and conspicuous, but under North Carolina's specific rules, when I was looking at New York Times disclosure, said it's not 12-point and bolded, so don't pass go, don't collect $200, let them go forward. And there are a number of other ones that we're tracking, so stay tuned as we're tracking those.
And I want to take 10 seconds to address. Somebody sent a question in early on about state laws and business to business transactions. And first of all, on B2B transactions, especially when your customer is a small business, the FTC rules will cover it. So the FTC, that's like well settled, they will go there. So far, we haven't seen the states very much go there. In fact, most of the state rules are written to define a consumer as a natural person or somebody who's purchasing goods and services for household purposes. So B2B has felt a little bit safer there, but we are now seeing a trend where the states are looking to cover small businesses in their laws. I think Colorado might have already done that. And there's a proposed law in New York State that would expand a lot of its maybe all of its consumer protection rules to cover B2B and add in different things. So anyway, that's something to be very careful of. This is a new development. So we've talked about B2B in the context of like payment processing agreements and equipment leasing and things like that. So I have to pay attention there.
That's absolutely right. And regulators have always gone after B2B, particularly in the small business. California Auto Renewal Task Force has done it in a number of cases. We haven't really seen this be litigated much, but as the laws are changing, we might not have that defense if you're doing B2B.
Go back to 24. I want to build up to this one. Okay, so the next question is going to ask the group. It's a poll question. We're going to do an in-person, like half day-ish, in-person presentation on all the vast issues, and we're thinking about doing it in either Los Angeles or take the poll question away, or it's too late now, or San Francisco. Before you answer, and to incentivize you to answer, I'm going to give the CLE code, which is Auto Renewals 25. Auto Renewals 25. And when we asked this question previously, it was right down the middle. If it's in Los Angeles, we'll do it in Century City. If it's in San Francisco, we'll do it downtown. Obviously, in San Francisco downtown, you can walk to a lot of places, no traffic. There's a lot of hotels around and everything else. Los Angeles is more spread out. But it's like the weather. I mean, if we do this in October, the weather's gonna be nice in both. And LA is in LA. You're near the beaches and what have you. So we want to do it where you all want to go, and we're trying to get as much feedback on this point as possible. So if you could just vote for us, it would be great. And we'll take that into consideration when we decide when to do this. It's probably going to be in the fall of this year. So give people a few moments. What are our results? I'm curious of all the poll questions. Oh my God, for 51% and 49%. And this time it's a little bit skewed to Los Angeles. When we asked in our newsletter, it was skewed like a couple percentage points to San Francisco. So when you average the two, at least percentages instead of raw numbers, it's literally split down the middle. So what we'll probably do is Los Angeles in 1 year, San Francisco is in another, but stay tuned. Make sure you're subscribed to our newsletters, and if you're not getting them, email one of us and we'll make sure to reach out to you because we want as much attendance as possible. Auto Renewals 25 is a CLE code. I think we're moving now on to tariffs. Shahin?
Sure. We've got a lot to cover, so that's why we're flying here, everyone. If you have questions, again, we'll get to them after. What's going on with tariffs? Well, I don't really know what's going on with tariffs. I don't think many people do. It changes on a daily basis. But one of the issues we've been talking when companies are selling any product, what are the impacts of tariffs going to be? We know that as a general matter, logistics issues are going to probably pop up if prices go up higher. We know that prices might increase as a general matter. The cost of input will increase, and therefore the cost of output and the sell the ultimate sales price might increase when you're selling on a negative option basis. As well as, what advertising claims are going to pop up. We know Ellen was talking earlier about what are material misrepresentations. So these are just a couple of the issues that you should be watching out for. If you're making made in the USA claims or country of origin claims, if those things change, then make sure that your claims on your website, as well as your physical packaging, are accurate. Don't let that the FTC or California plaintiff come after you because you got the wrong country of origin due to tariffs issues. Money back guarantees. If you're requiring people to send stuff back, make sure you account for that in the money back guarantee timing, as well as refund and return policies. You're going to have to adjust if those logistics issues are going to be factored in, as well as shipping representations. What does that mean? That means if you're telling somebody that they're going to get something within 2 days and they're not because things are slowing down on the shipping side and logistics side, then you need to be prepared to adjust those representations to avoid any issues there. So let's do another poll, everybody. What would constitute a material change that results from tariffs and logistics? With the understanding that, as Ellen said earlier, material change notices are required under state laws, many state laws. So you've got increased prices, delayed shipment, reduced value of product, or new country of origin, A, B, and C, or all of the above. We'll give you a few seconds to answer this one. I'll put my answer in. There we go. All right, let's see the results. How did everyone think on this one? Okay, all of the above was 83%, A, B, and C was 12%. Now, I think that we should be prepared for a challenger to say it's all of the above. How much of an increased price constitutes a material change? That's going to be a question that comes up. What is material? I anticipate that a regulator or challenger is going to say 1 cent is material. Why? Because if you have only a few amount of dollars in your debit account, you go underneath it, and now all of a sudden you're being charged an overdraft fee. Delayed shipments, that could be a problem if you're selling at a specific increment. You're charging somebody on day 30, but you're not shipping it until day 40. Then you start speeding everything up. That could be an issue. Reduced value of the product. Again, that could be an issue as well. New country of origin. I like the fact that we had 12% of people who don't think that this is material, because I do wonder. I wonder if that's going to be something that we do get litigated here. Our favorite part is enforcement, new challenges, risks, and what is happening. The FTC, we're seeing new cases, once every 1 to 3 weeks, which is almost more than we saw under the previous administration. What is one that we've seen recently? That was a case filed against Uber, challenging the Uber One subscription service. What that does is somebody pays a monthly fee, and for that monthly fee in exchange, they'll end up getting lower prices on their individual Uber rides. So if you're doing a lot of Ubers, people would sign up for this so that they could get that lower price. And Uber, according to the FTC, would charge either on a monthly or an annual basis. And what the FTC said here was a couple of things. They said that disclosures weren't sufficient on the front end. But I think what they really took issue with was Uber's cancellation mechanism. They said that Uber advertised that you could cancel anytime, when in reality, they would charge somebody before the billing date. So if you were within 48 hours of your next rebill, it was difficult for Uber to actually process those cancellations, according to the FTC. And the other thing that the FTC challenged was that Uber made it difficult for people to cancel. They said that people had to navigate at least 7 screens that required 12 different actions to get there. What constitutes a screen? Is it the login and then you navigate to the account and then you get the cancellation? We don't have an easy answer for you. But what we can tell you is that right now this is a filed lawsuit. There's not a settlement. So Uber might be fighting this one. We also know that Match.com is fighting another lawsuit over in Texas. And so we are closely following that. The FTC challenged, I believe, 6 or 7 screens in that case. And the court allowed the FTC to proceed, at least on a motion to dismiss, saying that 6 or 7 screens might be enough to allege a violation of ROSCA's requirement that you provide an easily cancellation mechanism. Ellen, you want to?
All right, let's go. We got a new poll. All right, everybody, new topic sort of. So if you use a third-party platform with an out-of-the-box solution to create your website, can you be liable for disclosure and consent violations if you had nothing to do with the way that it looked? It's the platform's sort of platform. So can you be liable for what the platform is doing there?
Ashton, do you want to make that poll live?
Okay. We need a live poll.
Here we go. Now we got it.
Okay. 10, it's yes or no. So you get like 5 seconds.
All right, here we got our results.
Okay, good job, everybody.
98% of you said yes, you can.
Okay, so that's what happened in the next case. We have just 2 quick slides on this, and we'll go over it quickly. But obviously, we hear a lot when we're helping our clients figure out where to make disclosures and how to make them and where to put them on a page. A lot of times they will use a third-party software provider for something. There's a lot of e-commerce platforms out there and others, and they are very regimented and stuck in sort of where you can put things, and they have different tiles and different sections, and you only have so many lines to put disclosures, and it's always going to look like this for everybody. And in this case here, the software provider, this is sort of what their checkout page looked like. It was very generic. It's sort of I can't read it from where I am, but the language is kind of lighter gray. It's kind of smaller to see. I think it's vague. I think it's something along the lines of like, if you sign up for something that has a recurring billing, you're going to be charged. And then the rest of it doesn't help, because if you look over on the right side of the page, it looks like it's just like one price. It's hard to see unless you look down and it's a little bit smaller, that it's like something that's charging every 3 months. So this was a lawsuit filed against the seller of these products and services here for sort of failure to make clear and conspicuous disclosures. On the next slide, the same issue with like an auto-generated confirmation email. Again, these software systems often have a template for it. And so they'll say, this is our template. This is what everybody's confirmation will look like. And if their template isn't good, and if it doesn't include the right information that you need to have, you're going to be in trouble for it. So just a note to be careful there. I mean, we've seen other issues come up here in the past. Occasionally we'll have an issue where somebody leaves the environment, even if it's your website. Maybe you're moving over to use PayPal or like a buy now, pay later type solution, and you get redirected out and you never come back, and you miss the disclosures that you needed to have and see. Well, first of all, under the new laws, disclosure needed to be made now much sooner. But if you aren't coming back to see sort of that penultimate checkout page where the disclosures are sort of wrapped up, that's a problem. And we've had to deal with those cases. So
Absolutely. And regulators will say tough luck. We've had this conversation with the regulator, and they said, yeah, well, that's your problem. That's not an us problem.
So NordVPN got sued in the Southern District of New York in March, and part of the allegations involved this screen, where there were 3 choices made. We don't have a poll question for this, but you might want to ask yourself, does any of this comply in whole or in part with the guidelines that we sort of went through on the other slides? There's like this weird disclosure here that, it's in US dollars, but they have a disclosure about that may apply, but they don't really have a lot of other things. And so the allegations in the lawsuit centered around that Nord offered consumers what appeared to be limited time plans, but buried the disclosure in a drop-down feature that customers did not see until they clicked on it, and did not obtain affirmative consent to the automatic renewal offer. The post-purchase email, the allegation goes, did not contain the renewal terms either, and omitted information needed to cancel to avoid the subscription charges. Plaintiffs got really invigorated by the alleged fact that Nord charged the consumers 14 days before the subscription period ended, so they didn't have a chance to use the full subscription, whatever it was. I think the example that will show is it was like a year. And they made it exceedingly difficult to cancel. Users needed to navigate multiple windows and click a minimum of 2 additional buttons and provide a reason for their decision. And there were also these dark patterns about promotional pricing and customer service assistance before the cancellation would be processed. And since there's also New York law allegation, and this was in New York, the renewal notice failed to comply with that state statute, which mirrors a lot, by the way, if not exactly, California's statute, to include instructions on how to cancel in a cost-effective, timely, and easy-to-use cancellation mechanism. So if you go to the next screen, you see the checkout page there. And that's the disclosure, pretty outdated compared to the laws that are in effect relative to this. And so this is the page that was challenged. Is pretty self-explanatory. It doesn't have the things that it needed to have, and it'll be interesting to see how this checks out. I mean, maybe they do a survey and they figure out that the consumers weren't actually misled by any of this, and they're able to get past it that way. So let's stay tuned.
Okay, poll 7. All right. So I'll ask the question, but I'm going to have you answer it. So, all right, everybody. If you increase the subscription price for existing customers, do you need to send a notice and get consent? So is it enough just to send the notice, or do you need to send the notice and get opt-in consent too?
And we know at a minimum, a notice is required under the material change laws that we were talking about earlier. All right, why don't we see the answers?
This is tricky.
I know. Oh, this is a tricky one. Okay, good. All right, so I see here that 55% of people said sending notice is enough, and 45% of people say you need to send a notice and obtain opt-in consent as well. Well, the answer is actually not that clear. As people who advocate for you guys and our clients, we would say that sending a notice is enough. The laws make clear that all you have to do is send a notice, and that the California legislature wanted to say you have to get consent too, they could have done that. However, again, as with everything in this area, the law is not clear. Why? A lawsuit in February was filed against SoundCloud, which is a company that basically lets you stream music on an auto-renewing basis. A lot of issues in that case, but what we want to focus on now is the issue that SoundCloud increased its price at some point. And the plaintiffs in this case alleged that SoundCloud did not clearly and conspicuously disclose on the front end that that price might increase over time. And SoundCloud didn't disclose on the back end that it did disclose on the back end, that the price increased, but it didn't get the consent to that price increase. Why does that matter? Because under state laws, they say that you have to agree to the material terms of the transaction, which include the cost of the program. You have to get affirmative consent to that. And so the question becomes, is it enough to get affirmative consent here on this checkout page that the price is going to increase? Prices may increase, or as they say here, you have to seek or obtain consumers' affirmative consent for the price increase, or do you have to do both? That case is ongoing. We're keeping a close eye on it. I imagine that we're going to see if this case continues to be litigated, we'll get an answer by a court. And we anticipate also on the tariff side, if prices do in fact increase and companies are sending material change notices without getting affirmative consent to that, then we'll see what plaintiffs regulators are doing there. But one takeaway here is you should consider updating your on-screen disclosures to say that the prices may increase.
Okay. ThreadBeast. Okay, so this is a case that really boiled down to how challenging it was made to cancel, allegedly. Well, and so let's see what happened here. So these are the alleged facts. Was that we have a plaintiff who signed up to receive products. It was sort of expensive, $165 a month. They were unhappy. They tried to cancel, and the first step in the cancellation policy is to send in an email. And we do now know under FTC, this is under FTC click to cancel, you can send an email to cancel, but you've got to be able to pick that up right away. That could count as an online mechanism. But in this case, the email was sent in, and in response, the company sends a 13-page long membership cancellation form with lots of sort of information in it, all designed to sort of keep the plaintiff in the program. So there's a lot of issues going on here, but I think the cancellation sort of foibles was the crux of what we want to highlight. So this was filed under the California Automatic Renewal Law. And there are also some other issues in here too, because debit cards were used. And as we mentioned earlier, when you're using a debit card, there are sort of certain authorization and confirmation type requirements. So this all came to light here.
Another case was filed against Fabletics, and they got hit a few years ago by the California Auto Renewal Task Force. So I guess plaintiffs decided it's their turn. The allegations there was that Fabletics didn't clearly and conspicuously disclose the monthly membership obligation, meaning the fact that you had to be a monthly member, as well as the terms of the auto renewal. Now, one of the allegations was that Fabletics would offer a promotional member credit that you get basically one credit in exchange for a piece of clothing in exchange for $59.95 you paid monthly. And one of the things that they alleged was that none of the products that you could get using that credit exceeded that $59.95. And Fabletics had advertised you get $100 in value for only $59.95. And they said, no, they didn't disclose it. That's unfair. And that's a violation of the auto renewal law. The other thing we're seeing here was that they alleged that the credits expired after 12 months, and California's gift card law prohibits that. So again, you're seeing that coupling of some of these allegations here. Ari, would you like to talk about this case?
Sorry, I was on mute. This was brought by the government, by the California district attorneys in Los Angeles. And there's a lot going on here, although the core issue was failure to comply with clear and conspicuous disclosure requirements and failure to disclose the automatic renewal terms, including cancellation fees. There were a lot of other things going on in this case. We only got 6 minutes left, but this one's worth a read if you want to read, if you want to go through it. They attacked like the written sales contract. They're saying that didn't have the font in the written sales contract was not offset for the automatic renewal terms, and they were very particular when it came to that. But there were also allegations that it was difficult to cancel and that people could not call in. I mean, they could call in, but they wouldn't receive live operators or the ability to cancel easily. And so there were a lot of things going on in this case. If we go to the next slide, this was an example. I thought this was a little bit nitpicky, but this is what they did. They started off the complaint this way, showing that this wasn't clear and conspicuous because it's in the same, though it's in all caps, it's in the same, it's not offset. And either was the recurring payment authorization. And those arrows, I think those were in the original complaint. I'd have to check that, but I think those blue arrows don't come from us. Those come from the from the complaint. If we go to the next slide. This is bad. Now this one doesn't work. So while you can nitpick over the language in the sales contract, there are no disclosures on this online form. I mean, there's nothing here. It says 54. I mean, I don't even know what you're getting for 99 or 54.99. And you have a link to the general terms and conditions. So even if those are there, this is clearly not enough. I'm not sure if in this case the government sent out a civil investigative demand first, and Hawks just said, no, we're not making any changes, or if they just went right to lawsuit. But the other point about this Hawks pest control case is, other than the Match.com case, this looks like it's in full-blown litigation. The rest of the California automatic renewal cases have been settlements. Then you've got the New York case in Sirius. This one's a good one. This one focused. This was in New York. It focused on cancellation, the ability to cancel, and there were violations of ROSCA on that too. There's an interesting jurisdictional point here, which is the court said that the New York law did not apply nationwide because the people that were taking the calls that were reading the terms and handling the call center agents were not in New York necessarily, and so the conduct didn't occur there. But nonetheless, the court found that there were violations of ROSCA and the New York law because of the cancellation piece. Sirius just made it way too hard to cancel. This is coming from a state court judge. We only have a couple minutes left. In my opinion, it's one of the more balanced opinions, especially on the nationwide application of New York law. So this one was, I thought, decided relatively fairly based from what we could tell from the outside. We don't actually know what was going on inside. Drip pricing and pricing transparency, big issue. Who's handling that?
This is me, and we will do a webinar for you all on this issue alone, because there's a lot here. We're tracking the cases every day. There are multiple lawsuits being filed under the new California's drip pricing law. In a nutshell, it basically says that you have to advertise the total price of the product or service upfront. You can't give a base price and then once somebody's sort of in the shopping process, then tell them that there's a service fee added onto it or whatever else. And we mentioned earlier sort of how these types of things are getting coupled up. This is a coupling opportunity for a lot of plaintiffs' attorneys. If there's a lot of sort of ways that we can see this come out. First of all, it's a required disclosure to disclose the price of an item that you're going to charge on a recurring basis. So if you're giving somebody a price, but you didn't add in the $4.99 service fee that you're adding in every month to do whatever, and you don't disclose that up front, you now have two potential claims under two different laws. So other things, we see a lot of cross-sell offers and upsell offers at the end of shopping experiences. And so like shipping insurance and shipping protection type things is one thing that comes to mind. And those are often subscription programs, and maybe it's a third party, and so maybe there's arguments there that it's a separate fee, whatever else. But if it's teed up as sort of something that's required for the product or service, and you didn't include it in the total price, is that now a problem? So we will address all this, I think, under a separate cover, as they say, but wanted to.
And the one thing here is that just because somebody can uncheck that on the checkout page, plaintiffs are saying that's not enough. That needed to be disclosed upfront.
There you go.
All right, key takeaways. Of course, everything is changing. So, we could do this webinar next week and we could have different things that we're saying. And even if the click to cancel rule doesn't withstand the legal challenge or FTC's enforcement priorities change, class action plaintiffs and state AGs are very ready and willing to file lawsuits. As we said, we're seeing, I think, a new lawsuit file at least one every day or every other day. Same with the drip pricing things. Class action plaintiffs and state attorneys they're very, very creative. They're wily. They're using what they can to get the money that they want. And becoming and settling these cases. I mean, Ari, if you have questions, you can call Ari, but we can all tell you that the price of a settlement has gone up incredibly. I guess inflation has hit the class action plaintiffs bar as well. And when you're doing these things, when you're creating your practices, when you're creating your policies, even in internal communications, think about how you're going to defend them. Think about what are we going to say when you get a complaint or a letter? What is that motion to dismiss going to look like? Just really be mindful of that. It's not on here, but again, we always say, think about your mandatory arbitration provisions and class action waivers. There's a lot of new cases under whether or not those are even enforceable. The Ninth Circuit has become incredibly persnickety. So a lot of those that we thought might be enforceable 2 years ago or even last year, you should be taking another look at it in light of about 3 cases that have come out since January from the Ninth Circuit. And we've really flown through this one today, but we will respond to the questions afterwards. Ari, I forgot the CLE code. Do you remember it?
We said it when we were doing the poll question.
Say
It was
it again,
auto renewals 2025. Auto renewals 2025. Auto renewals 2025. That's the one with an S.
And if you have questions afterwards, please feel free to email us. And we're here for any questions, and we'll be doing follow-ups. So keep an eye out on your emails and for other webinars that we'll be doing to keep you all in the know about what all's going on. Thank you for joining.